cloud.
Okay.
You know what, though? Actually, I have a quick question. If I record on the cloud, would it go to your account, Kylie, or mine, since I'm the host now?
Either one, I think it would be yours actually, and then you can email it to me.
Okay, sounds good. Anyway, so it's very nice to meet all of you. I think we're going to have a cozy affair here. So I actually really prefer this. I get a little bit of stage fright here. So hopefully it'll just be us. But anyways, my name is Nancy Mendez. I'm an estate planning attorney. I work in the Ventura County. I'm licensed in California, which does mean that I can work all over California, but my home base is Ventura County. I do have licenses in Washington and Wyoming, but I only accept clients in Washington for now. Maybe I'll do Wyoming in the future if anyone needs a Wyoming trust. But California and Washington are very similar, not just because of the liberal aspects of it, but most so because they kind of match each other with the laws. So it works out pretty well together. I speak Spanish. I have been an attorney for 7.5 years now. I just opened up my law firm. About 2 years ago now. I'm the big boss. I'm really excited to be the big boss. So if anyone ever wants to chat with me, it's me that they chat with and not with an assistant or a secretary or something like that. That's also really important in the Spanish speaking community. It's kind of my pet project to be an attorney for the Spanish speaking community, which is a very underrepresented community with respect to estate planning. So what I'd like to do today is just start my presentation. If you guys have any questions in the interim, go ahead and feel free just to ask me. I do kind of want to have a more dialogue situation as opposed to a presentation, although I will have a PowerPoint. But again, if there's anything that you want to ask me during or anything like that, go ahead and ask me during. Now, if there's something specific, if you want to throw a scenario at me, let's save that for the ending. But just like I said, if there's a clarification you need while I'm going through it, please feel free to go ahead and ask me during. Alrighty, so let's see if I can get this done in quickly with respect to sharing my screen. Okay, can you guys see my PowerPoint?
I can.
Excellent. And let me see if I can get it started. I think if I do that, right? Oh, like that. Is that it? No. There we go. I think that's no. Does anyone know how to? Oh, here we go. Slideshow from beginning. All righty. Can everyone see the slideshow without it looking like it's being edited? Very good. Okay. So like I said, what I'd like to do here is just kind of go over a basic estate planning. And again, like I said, feel free to ask me any questions in the interim unless they're specific scenario questions, which I think we can share that for last. So the big question is, what is estate planning? So estate planning is the process by which a person prepares various legal documents to avoid probate. That begs the question, of course, what is probate? So probate is the process where the court gets involved with respect to distributing assets if somebody dies, what's called intestate. Intestate meaning that someone dies without doing their trust, their will, power of attorney, any of that stuff. The big reason why we want to avoid probate is, of course, cost, it's money. So some of the costs associated with probate are attorney's fees. And I just really want to briefly tap on attorney's fees with respect to probate. And Kylie, you probably know this very well. And if any of you are involved in the probate process, you know that fees are statutory. So what does that mean? It means that the court will look at the total value of the assets. And that means if there's real property, if there's vacant land, anything with respect, anything that has to go through the probate process, it will have a value on it. And then attorney's fees are a percentage of that value. It works out to be about 11%, generally speaking. And here in California, that can get pretty pricey. You know, a house here, I think on the lower scale might be $600,000. And right there, you're looking at $66,000 just for attorney's fees. So it's definitely a pricey way to go if somebody dies intestate. The other fees are for your executor or your trustee, and that's just the person who's going to be managing everything. And last but not least is filing fees. Filing fees can get pretty expensive. You also have to publish it in the newspaper, give a ton of notice to a ton of people. So it does get pricey just with respect to filing fees. I also want to talk about the fact that what I listed here in this probate process is an uncontested probate. What that means is, let's just say all the siblings are in complete agreement. Hey, mom died, mom left nothing. So we're all going to go together and ask the court to give us the ability to administer the estate for mom, the intestate estate. Now, if it turns out that siblings are not in agreement, this process right here is going to be a lot longer and a lot more expensive, because it will be contested. So this is the best case scenario of the worst case scenario. And we don't want to go deeper into the worst case scenarios. So I want to generally kind of give you a very quick overview of the types of trusts that are very common. The first one is the revocable trust, which is the most common and what's mostly used by just the general population. So it allows the trust creator to change it up to the point of death. So that means mom and dad can disinherit you up to the point that they die. So that behooves you to always behave. The trust creator still remains the owner of the assets. And what that means is, let's just say that the trust creator puts a house in the property, but then decides to sell it. The trust creator still has the ability to sell the house. Another great example is a jewelry. If somebody says, hey, my wonderful wedding ring, I'm going to give it to you when I pass away, that is a contingent gift, and it will be contingent up until the time that the person passes away. So if they decide to sell it or gifting it to someone, they're able to do that as well. So basically, revocable means that it's revocable, it's changeable, it shifts with you, it shifts with everything that life happens. Now I want to get into what an irrevocable trust is. Generally speaking, an irrevocable trust only applies if your assets are over 12.6 million. Now, why is that? It's because estate taxes don't start getting charged until you have assets that are over 12.6 million. And then after that, you're hit with very, very expensive estate taxes. Like we're having a little.
Tyler told both of us to watch us, and I just.
Sorry, hold on. Nancy, can you mute Jenna? Perfect. Okay.
Perfect. Where did I leave? Oh, yes. So generally speaking, irrevocable trusts are not necessary for yet for us, right? Because maybe we will have 12.6 million in the future, but not now. But generally speaking, the reason why we do irrevocable trusts is to go ahead and gift all of our assets to somebody before you get charged all of that estate tax. And like I said, it's very expensive to have estate tax, but generally speaking, for the average consumer, you don't really need an irrevocable trust. I just want to briefly touch on something that's been happening a lot lately, and I think a lot of it is probably due. I don't know what's going on in TikTok, but I have a feeling that it's due to TikTok. But a lot of people are getting the misunderstanding that we do trusts to protect our assets. Now, generally speaking, yes, a trust can hide your assets, but it doesn't protect your assets 1000%. The reason for that is because any smart attorney can just look up, okay, well, there's this home and let's see if it's in a trust. Okay, well, let's just see who lives there. It's very, very easy to discover who is a beneficiary of a trust, even though the beneficiary is technically private. Now, I think I also want to just very briefly go over the fact that when we protect our assets, it's because we don't want to have judgments or liens against our property. In order to get to that point, it's very, very hard. That means that you have to have a complaint filed against you in a court. And that means that you have to either not respond or lose the case. And generally speaking, a lot of times these cases are settled. So if you're ever in a situation where you're in a car accident and you do get a lawsuit filed against you, I can 90 out of 100 agree that it's probably going to get settled. So you are not in this position where you're going to have your assets seized from you. So I just kind of want to clarify that misconception about there's this fear that we're always going to get sued and always have our property be taken away from us. That's really not the way it works. It's very, very long for us to get to the point where someone can actually file a judgment lien against your house. Anyway, I went on a tangent there, but the last type of trust that's pretty common is a special needs trust. A special needs trust is used for a person that needs to qualify for certain services, for any public assistance services. I'm sure many of you know that those services are offered on either a need basis, and you also have to qualify for those services. Let's see, it looks like we have another person here. One quick moment. You also have to qualify for those services on a financial basis. So a lot of times, let's just say that there's someone who needs special needs and they need those services, but they're standing to inherit $1 million. Well, obviously, those services will be cut from them if they do inherit $1 million, because the state then decides that you should be using your assets to pay for whatever needs that you need. If you create a special needs trust, essentially all of your assets are not yours anymore. They're your trusts. So then you can go ahead and qualify for those services. And that also applies to Medicaid. I apologize, Medi-Cal planning. A lot of my clients want to apply for Medi-Cal in the future, and creating a trust will allow them to apply or qualify for Medi-Cal in the future. Now, there is a look back period that you have to think about. It's a 2-year look back period, but let's just say that you create your trust in 2023 with your intent to qualify for Medi-Cal in 2025. So that's when you qualify for Medi-Cal services after that 2-year look back period. And if anyone has any more questions about that, we can chat about that. I'm going to move on a little bit here. Does anyone have any general questions with respect to anything that I have just explained? Beautiful. Let's keep going. Okay, so I just want to briefly talk about what goes into a trust. So the very big thing, and this is the biggest reason why we do trust, is to put our assets with title and trust. That's our houses. Those are our mobile homes and any sort of vacant land. Essentially anything with title besides boats and cars, but any real property would definitely go into your trust. You can also create a bank account that has a very limited amount of money for your trust just to fund it as well. The other thing that we would like to put in a trust is your business. So the trustee will have the ability to manage a business if you unexpectedly pass away. And this is also why I let my clients know that if they do have a business, they should also have an operating business that basically locks in with the trust. For example, let's just say that you have a business selling strawberries, and you would like to then, if you were to pass away, you want to make sure that that strawberry business is wound down, sold, and distributed among your beneficiaries. Your trustee would then have the ability to do that. But those instructions about how you want your business to be wound down would have to be in your operating agreement. This is also why I also do a lot of business consulting, because having an operating agreement is very similar to having a trust for your business, in the sense that you're leaving a set of instructions in the event that something unexpected were to happen. So again, let's just say that your operating agreement says, if I were to pass away, I want my other business partner to have the right of first refusal to purchase this. Very good. Okay, the trustee would make sure that that would happen. So I'm hoping that you can see how they work together. Basically, the trustee would be able to do everything on behalf of your business with respect to the instructions that you specifically left in your operating agreement. The other thing that goes into a trust that's very pretty unique to California is guns. So guns, we all know this, guns are heavily regulated in California. So depending on the type of gun, you may need a separate trust called the gun trust. So there are only certain types of guns that you want to put into a trust. It's Title II guns, so they're not very common unless you're a gun collector, and those are going to be like your antiques. Those are going to be like your smaller guns. Those are going to be like not just Glocks or pistols or anything like that. Just the more uncommon guns likely are going to need a gun trust. And the reason for that is because they're not as they're just a little bit more uncommon. The other thing I want to mention with guns is if you do have a gun and you don't want to put it in a trust because it doesn't need to be in a trust, but you do want to make sure to recognize the gun in your trust. First of all, the first question I ask is if it's registered, because if not, we're not talking about it anymore. But if it is registered, what you do want to do is you want to make sure that you only gift it to your children. Now, California guns can only be transferred to your direct children. So if for example, you have grandkids and you want to transfer a gun to a grandchild, that's absolutely not allowed. California does not allow that. So what do you do in that sense? What you would do is leave instructions saying, I would like my gun to be sold to a licensed dealer. You can't just sell it to anyone, but it has to be to a licensed dealer. And then the net proceeds of that gun would be distributed to your beneficiaries. And maybe you can distribute it to your grandchild if that's what you would want to do. But essentially speaking, guns are a whole other ballgame with respect to estate planning in California. Does anyone have any general questions before we move on? All righty. All right, what does not need to go in a trust? So those are our pay on death accounts. And I did put a note, update your beneficiaries. I just want to go over really quickly what pay on death accounts are. One of them is bank accounts. Very easy. And what I mean by that is when you opened up your bank account, it's very likely, even if you don't remember or not, but when you filled out your form, they asked you, who would you like to be your pay on death person in the event that you pass away? If you're married, you put your spouse. You maybe put your mom, brother, sister, whoever, but you did put someone on your pay on death account. A lot of my clients say, well, I don't think I did that. And I'm like, I know you did. You just probably forgot. And that's because we opened bank accounts from a long time ago. We have them for a long time and then we forget who we put. So pay on death accounts, that's what it would be. Retirement accounts as well that have a beneficiary. Life insurance policies also have beneficiaries as well. So those are, again, what are called pay on death accounts. So my note with respect to update your beneficiaries, this is super important. And if anything you learned from today, this is going to be the most important thing. Once you have a trust, you need to make sure that your trust is also a secondary beneficiary of these type of accounts. Now, why is that? And this has happened to me several times, and this is why I'm saying this. If you have a trust and you have, let's just say your life insurance, and you put your spouse as your primary beneficiary on your life insurance policy, and then your spouse passes away, and you forget to update anything on that, and then you pass away. Now there's a life insurance policy that has absolutely no beneficiary. Depending on the state, and as you know, a lot of states hold a lot of different life insurance companies. Depending on the state, you're going to get pushback even if you have a trust. The states are going to say, hey, this account does not have a pay on death person. It's not in the trust. You need to figure out a way to have an order from the court to allow us to release this to your trust. Of course, here in California, probate is not a fun thing. I think a lot of other states have a misconception with probate in California because a lot of states sometimes always have to open probate. We're very lucky that we don't have to do that. So basically what I'm trying to say is once you create your trust, make sure that your trust is a secondary beneficiary to your accounts in the event that your primary beneficiary passes away. As we know, a trust can never die. Well, it can dissolve, but generally speaking, a trust will not die. So that means if mom dies, if dad dies, if the kids dies, if there's no more heirs, the trust will receive it. The trust will find heirs and distribute it to your family based on the family tree of whoever is next down the line to receive assets. Again, update your beneficiaries once you have a trust. All of those life insurance policies, you need to put your trust in there as a secondary beneficiary. I hope that stuck in your mind. Other things that don't need to go in the trust is cars. Cars are very simple. Once someone passes away, you can just have that transferred to the new trustee or whoever's going to receive the car. So that's generally speaking, attorneys don't do anything with cars. And then personal items. That's rings, jewelry, watches, anything like that. What we will do is create a list of what you want to happen. Like maybe you want that wedding ring to go to your son. Maybe you want something else. Let's just say that Hermes bag that you have, you want it to go to someone special. We can list all of that, but it certainly won't be titled in your trust. So what is a trustee? So the trustee is the person in charge of carrying out the instructions found in the trust. So basically it's your administrator. It's the person who's going to be making sure that everything that you asked for is done properly. So the initial trustee is you. You are the initial trustee. You created your trust. So you're the trustor, you're the trustee, you're the beneficiary, you're everybody. You're the CEO of your trust. Now, once you pass away or once you're incapacitated, that's when we have to start chatting about different persons filling in those roles. So once you pass away, then your successor trustee, a lot of times if you have children that are over the age of 18, people like to put their children. So once you pass away, your child would be your new trustee and they would start administering your trust based on the instructions that you left. So what are some of the powers that the trustee has? They have the power to sell your property, to give specific gifts, to pay debts, to file taxes on your behalf, to file a court case if needed, and any other power that's listed in the trust. Also, it's just any power that is needed in order to administer the trust, your trustee will have. Any questions with respect to that? Very good. So I just want to go over wills. So there is a difference between trusts and wills. A lot of times, I think, and especially in the Spanish language, there's some misconceptions with respect to what a will does and what a trust does. And again, I think that's just a translation issue, but a will basically allows you to leave specific instructions regarding the distribution of your property, your possessions to certain beneficiaries when you die. A lot of times when you have a trust, you have what's called a pour over will, because everything that you put in your will would basically be poured over into your trust, and then it would follow the instructions of your trust. So I also want to kind of talk about the different thing that the will does as opposed to a trust. So what the will does is it gives general power to your executor to do things on your behalf when you pass away. The easiest example that I use is, let's just say that you were about to get a settlement check for some lawsuit, and the settlement check has already been cut, and you're just waiting for that mail to come so that you can have your settlement check. And in the middle of that, you pass away for unrelated reasons. So now there's a check in the mail for $10,000, let's say, that doesn't have a beneficiary because you passed away. So it's not the trust that would give your executor power to get that check and deposit it in the trust account. It would be your executor of your will that would have that power. So that's why a lot of times, and almost always, attorneys recommend that your trustee and your executor are exactly the same, so that there's not power here and power there. So does that make sense? And I'll say it again. Basically, your trust is there to hold your assets and to protect all of your assets that don't have life. And your will is there to protect you as an individual person. Once you've passed away, your executor is going to have that power through the will to take care of anything on your behalf once you've passed away. That's the general difference between a will and a trust. The other thing that the will does that a trust does not do is guardianships for minors. So if anyone has minor children, Kylie, I'm looking at you. Beautiful minor children. If anyone has minor children, it's not going to be the trust that takes care of saying, this is who I want to take care of my children if me and my husband pass away at the same time. No, it's going to be your will that nominates that, because again, the will is for you as an individual person. The trust is just this company, this cold contract that you made to handle your business or your finances, I mean to say. The will is for you as an individual. Any questions with respect to that? Very good. Now, quickly, I just want to chat about power of attorneys. That's also part of what estate planning is. So we've talked about our trust, we've talked about our will, and then of course, there's the power of attorney. Now, the power of attorney is generally only used when somebody is incapacitated for whatever reason. And incapacitation might mean that you decided to go on a trip to Iceland and you needed something to be taken care of in the interim, and you nominated your spouse to do so while you're having a great time in Iceland. You could use a power of attorney for that. But essentially, it gives the agent the power to act for that person if they're either incapacitated or not able to act. So they have the power to sell assets, to pay bills, to open and close bank accounts, to request copies of financial documents, basically anything necessary anything that the power of attorney said you can do. But it also, like I said, is basically a financial power of attorney, just to make sure that anything that needs to be done during the interim can be done. Now, I just want to stress the importance of having a power of attorney. It's a very simple document, but the importance of this document is, it's amazing. The reason for that is because if you were to ever become incapacitated, and if you don't have a power of attorney and someone needs to do anything on your behalf, let's just say take care of you, pay your bills, maybe sell your house so that they have money to take care of you. Without a power of attorney, you need to ask the court for a conservatorship. And doing that is very expensive. It is very statutory. Everything needs to be done to a T. And in addition to that, the court will be involved in your life for a very long time, forever, essentially. So I know that it's not very fun to have court oversight on everything, but the court requires reports every 6 months. So it's just very, it's not recommended to have a conservatorship through the court because it is costly and it is very time consuming, and you have to keep up with the court constantly, which is not very fun. Let me see, it looks like we have a
Man, I had a question. It's actually a good question. In California, if you're married, can your spouse have the rights to decide for you without a power of attorney?
So generally speaking, yes, but a lot of times if there is conflict, like let's just say that a spouse wants one thing and then there's any contest or conflict with that, then it would, and we've seen this happen all the time. This is when conflicting conservatorships would have to be open because there's a conflict on that. But generally speaking, yes, a spouse can decide on your behalf, but in very limited situations. Let's just say if it's something with respect to your health, which we'll get to in a minute, then yes. But if it's something like sign on your behalf to sell a house, that's going to be a no. So to amend that, it's just yes, generally, but it's going to depend on the situation. The attorney answered, it depends. Do you have a follow-up question on that? Thank you. Clicking to the next one. Okay. So a healthcare directive. In some states, it's called the living will. So it gives the agent the power to make health-related choices on behalf of the person. And this is really what I was talking about. If you are married, it's very many times that hospitals and things like that will let you decide on behalf of your spouse. When it comes to financial matters, it is different, but with respect to healthcare decisions, usually hospitals, doctors will adhere to what a spouse says. But again, if there is some sort of conflict with mom wanting something different, mom and dad wanting something different than dad or than your spouse, then you will run into issues where it's likely you're going to have to file a conservatorship. So back to our healthcare directive, it gives the agent the power to make health-related choices. So it can be effective immediately upon signing if need be, or when the person becomes incapacitated. So it's basically addressing a number of possible end-of-life care decisions. For example, if you're in a coma and in a vegetative state and the doctors have already determined that you're probably not going to come out of that coma, if you want to be kept on life support or taken off life support. Also, organ donation is a very big one as well. If you want a specific organ to be donated to a specific institution for research, if you have some sort of something unique about an organ, you can do that as well. If there's type of medication that you do not want to be administered for health reasons or for religious reasons, this is where we would put all that information as well. And that is the end of my very brief presentation. I do want to open up the floor, though, to any questions. Like I said, I want this to be a dialogue, so I'd love to answer any questions that you guys have or any clarification that you would like.
So I have a question really quick before other people jump in. So in respect to real estate, is there any tax benefit to having your home in a trust or long-term or short-term when you start that?
Yes. So a lot of times I think there is a belief that if you just put title to your children now, then that takes care of the problem because your kids will then have the property. Well, the law just changed not just, but it changed in 2019. So if you do any sort of transfers that are not with respect to a married couple or a couple other exemptions, then your property taxes will change. So it's the reason why they invented this law was to make sure that very wealthy people are paying their taxes, but unfortunately it's people who maybe have one or two properties that get affected by it, just very small investors, things like that. They're the ones who ended up getting affected by this law. But essentially, if you transfer your house to a trust, property taxes will not change. Now, with respect to your personal taxes, not really. There's really no benefit with respect to personal taxes, but property taxes, yes. I'm going to take down the stop share just in case anyone wants to jot down my information. Okay.
I do have a question. How are you? My name is Christian. We actually spoke on the phone. So
Oh,
twice.
yes.
In regards to property taxes, when you put your house in a trust, instance, knowing that the property taxes are above 7, if the property taxes were to ever go lower, if the house is in a trust, can you refinance and take advantage of the new tax rates?
Definitely. So the
Okay.
really beautiful thing about having a revocable trust is you can do whatever you want. If you want to refinance, if you want to change, if you want to add, if you want to subtract, if you want to disinherit someone, you can do all of that. So I will say it's going to depend on your lender whether you have to take it out of the trust and put it back in. And I say that because I've heard conflicting things from lenders. I've had some lenders tell me that, oh, we don't need to take it out of the trust. We know what to do. And then I've had other lenders say to me, yes, we need to remove it from the trust first, then refinance, and then put it back in the trust. Nevertheless, it's not that hard to take it out and put it back in. It's just paperwork filing. It's filing, recording a quitclaim deed, and then recording a grant deed back again into the trust.
Copy. Now you said revocable?
Yes,
Irrevocable? Okay,
revocable.
revocable. Okay, perfect.
So would that be the kind of trust you would want to set up in that instance?
Generally speaking, yes. If you want flexibility, you're going to want a revocable trust. If you are not worried about the estate taxes, then a revocable trust is going to be the way to go. And again, remember, estate taxes don't start being charged after 12.6 million.
Copy.
Question, when I see on title and I'm looking at title for people and I see living trust, what does that mean? Like
You
the
mean when
person
they're
alive, but then why don't all of them say living trust?
There's special needs trusts. It could be any sort of trust. It could be a Medi-Cal saving trust. It could be a realty trust. It's just a type of trust. So again, you can name your trust anything. I have a lot of clients that don't want to put their full names on it, so they'll just put the initials, revocable family trust. Sometimes it could be the revocable living trust. It just really depends. If it's a revocable trust or a revocable family trust or a revocable living trust, it's all the same. Now, if it says something like special needs trust, then that will be a different type of trust. Or like I said, a realty trust.
Got it. Okay. That helps explain a lot. Does anybody else have questions?
Shoot them at me. Shoot me the scenarios.
Nancy.
I have one in regards to the healthcare direct. So how can I put this? Is this the same thing as a medical power of attorney?
It is, yes.
Okay.
So there's just going to be different names depending on the state. A living will is another way it's called. A living will and then a medical power of attorney are the same thing. In different states, like Washington is actually an example of that. They don't have what's called an advanced healthcare directive. They
Okay.
have both a separate living will and then a separate medical power of attorney. California combines them both, and it's just called an advanced healthcare directive.
Copy. And when you do become, for instance, when you hold the power of attorney over someone's medical, what effect does that have to the person holding the power of attorney?
I think with respect to the effect, that means that you need to have a fiduciary duty on the person that you have power of attorney over. But with respect to any ramifications like taxes or property or anything like that, there's no effects in that sense because you're not holding title to anything, or you don't have anything. You're essentially stepping in the shoes of someone else and acting on their behalf. Does that make sense? Basically, you're not receiving anything of value. You're just acting on behalf of someone else.
Okay. All right. Yeah, it makes perfect sense.
Any other questions or scenarios? Great. Well, like I said, the one thing that I really wanted to harp on you guys is once you decide to create your trust, make sure that everything is done. It's not just creating the trust, it's also making sure it's updated, making sure that all of those T's are crossed and those I's are dotted. What I mean by that again is if you do have other insurance policies or any investment policies, make sure that your trust is a beneficiary on that. If you have minor children, also make sure that you've got a guardian that you trust. A lot of times I've had people do separate guardianships and separate trustees for their children. Let's just say they are going to have a college savings account for their children, but they don't really want the person taking care of the child to also have access to that 529 or manage it. Maybe they're not good at managing money. You can do that as well. So it looks like we have a question. So there is a really, the question is any specific recommendations you would make to single parents when implementing a trust? So I'm assuming the question is related to guardianships. So guardianships become much more important when you are a single parent. If the other parent is involved and you don't have any sort of guardianship for your side of parenting, then it's very easy for the other parent just to say, well, no one on mom or dad's side of the family is there anymore. So I'm just going to go ahead and take the child and do whatever I want. A lot of times there's a lot of familiar bonds that can be broken like that. Let me give you a scenario, an unfortunate scenario where a friend of mine passed away, and he had visitation rights with the daughter of his, but he did pass away. Didn't have any sort of estate planning or anything. And the mother of his children took the children away to Nevada. Unfortunately, his family here in Ventura County still wanted contact with them, but because of the fact that he didn't live a guardian for his side of the family, they weren't really able to have any sort of recourse or any standing with respect to asking for visitation rights or anything like that. So when you are a single parent, it also is important to factor that into creating a trust. I hope that was where you were going with that question. And if not, I'm happy to clarify.
Yeah, you can get more specific too while she's here, because it's like free legal advice. I mean, if you want to ask her directly, or you can message her if you don't feel comfortable in the group, that's totally fine too. Nancy's amazing.
Thank you.
I did want to ask your recommendation. So when purchasing a home, let's say I'm purchasing my first home, is it recommended to already start the trust before signing the documents, or having everything settled and then opening the trust?
So that is going to depend on your lender. And the reason why I say that is because I've had different scenarios where a lender will tell me, I can't put the house in a trust because the person who purchased the home and the person who's what's the word I'm looking for? The borrower needs to be on the title. So in which case you're going to have to re-record a grand deed anyway. So you're not really saving any fees on that. Some other lenders are very okay with that. And they're like, yeah, sure, create your trust. We'll put it in the trust. No worries. So again, it's going to depend on the lender, but you can always, let's just say that you buy a house and it closes tomorrow and you want to put the house in a trust the next day. That's perfectly fine too.
Okay.
Yeah, people do it all the time. Like they'll purchase it in their names and they'll transfer it. I have a situation right now where I'm closing next week. And because they didn't want to complicate the documents on title, they just bought it in their names. And then their plan is to transfer it to their trust right when they close.
Yeah,
Copy.
and that's very, very common. So there's no benefit to doing one or the other. Like I said, if you want to kind of get your ducks in a row early, you can, but also it's going to depend on what the lender says.
Okay.
We have some lenders in here right now. Jenna, if you've ever been asked that question, I'm curious. I don't know if she hears me. It's dinner time over there. She might not hear me.
I'm here. Yeah, almost always we just close in their names and then we roll it into the trust afterwards, because like you guys were saying, it just complicates things
Okay.
and more documentation. So it's just easier to do it that way.
Got
All
it.
right. Thank you.
Of course. So
You're
what I'm going to do is I'm going to drop my information again in the chat for everyone. I think that should do it. Let me know if you got that. So that, like I said, I'm located in Ventura County. If anyone has any questions, I do give free consultations. And the reason why that is because I really am passionate about educating people with respect to the importance of estate planning. So I'm happy to help in any way. And any final questions or anything?
Don't be shy.
I don't bite.
Well, thank you, Nancy, for doing this. I really appreciate it. I really, really appreciate it. And I think, a lot of people don't realize the importance of it until it is too late or relevant in their life. So if anybody has questions now or after, save Nancy's information. I'm going to email a recording of this to all of you that have registered. So if you want to send it to anybody in your family or somebody that couldn't make it on to listen with you, a lot like spouses, family, friends, whatever, you can send them the link as well.
Perfect. Thank you
Perfect.
so much.
Of course, happy to help.
Thank you, Nancy.